So excited to have you here. This is a great turnout, and we're so grateful to be able to have Professor Arkes speak with us today. This is the first event of our Respect Life Week programming, which is starting today into the next week. And if you want to hear about all the rest of the events that we have cards on both sides you can take with you to see all of the things that Right to Life is doing. First, we'd like to thank all of the co-sponsors of this event today, the DeNicola Center for Ethics and Culture, the Center for Citizenship and Constitutional Government, Jus Vitae, Notre Dame Campus Ministry, and the McGrath Institute for Church Life. Thank you so much for everything you've done for us, and I'm going to give those people a hand. Today we welcome Professor Hadley Arkes. Professor Arkes has been a member of the Amherst College faculty since 1966, and since 1987 he has been the Edward Ney Professor of Jurisprudence. In 2016 he assumed emeritus status. Professor Arkes was the main advocate and architect of the bill that became known as the Born Alive Infant Protection Act. Professor Arkes proposed to begin simply by preserving the life of a child who survived an abortion, and argued that such a child must be protected by law. On August 5, 2002, President Bush signed the bill into law with Professor Arkes in attendance. Professor Arkes has written 5 books with Princeton University Press, and his most recent books have been written with Cambridge University Press, including Natural Rights and the Right to Choose, and Constitutional Illusions and Anchoring Truths, the Touchstone of Natural Law. He has become known to a wider audience through his writings in the Wall Street Journal, the Weekly Standard, and National Review. He has been a contributor also to First Things, a journal that took its name from the book of that title. Professor Arkes is the founder of a new center for the jurisprudence of natural law in Washington, D.C., the James Wilson Institute on Natural Rights and the American Founding, named for one of the premier legal minds among the American founders. We are so grateful to have him here to speak with us today. Please give him a warm welcome.
Thanks, Merlot, and thank the people who did all the work to invite me. And thank you all for coming out at midday for this talk. But that introduction makes me think of that cartoon years ago in the New Yorker of a figure, 19th century garb, pointing out in the distance, and on the tablet was inscribed, statesman, author, patriot, but still a disappointment to his mother. So with that, I'm up. I also want to acknowledge the presence of Father Miss Campbell and Professor Bradley. And you'll notice all the time I'm speaking, Jerry's lips are not moving. It's never out of season to recall Aquinas' line, that the divine law we know through revelation, but the natural law we know through that reason that is accessible to human beings as human beings. We might say natural to human beings. And in all my work and teaching, the example of natural law reasoning which is more quickly and readily understood involves that fragment that Lincoln wrote for himself, imagining a conversation with an owner of slaves, putting the question, why are you justified in making a slave of the black man? Is he because he's less intelligent than you? Ah, beware, the next white man that comes along, more intelligent than you, may rightly enslave you. Is it because he's darker, with a lighter skin having the right to rule the dark? Ah, beware again. The next white man who comes along, with a complexion even lighter than yours, may enslave you. The upshot, there was nothing one could say, in principle, that would justify the enslavement of the black man. That would not apply to many whites as well. And some of us, of course, years ago began to draw on that same mode of principled reasoning in arguing about abortion. That why is that offspring in the womb anything less than human? Does it speak yet? Neither do deaf mutes. Doesn't have arms or legs? Other people lose arms or legs in the course of their lives without losing anything necessary to their standing as human beings to receive the protections of the law. And the upshot, once again, is there's nothing one could cite to justify removing unborn children from the circle of rights-bearing being that would not apply to many people walking about well outside the womb. It's simply principled reasoning. You don't need a college education to understand it. It is grasped across the religious divide, understood by Baptists, Protestants, Catholics. It could even be understood by Cub fans, Chicago Cub fans. We used to call my neighborhood the army of the credulous. But the point here is you don't have to be Catholic to understand this argument, and that has been precisely the teaching of the Church. It's not a matter of appeal to faith. It's a matter of appeal to embryology, the evidence of embryology woven with principled reasoning. Now, in this vein, I began to write in the pro-life cause in 1972, before Roe versus Wade. And I've sounded the argument in books such as First Things, Natural Rights to Choose. I lament so many friends who worked so hard on this cause who did not live to see this day with the overturning of Roe. Still, we need to ask, did that overruling of Roe in the Dobbs case really declare and pronounce the wrong that we worked so hard to undo? And has that decision really laid the principal ground for our jurisprudence going forward? Thinking about this point is when I recall that scene after the Battle of Gettysburg, when Lincoln was trying to prod General Meade to get himself together and strike at Lee's army before it got back across the Potomac. And Meade held back and lost the moment, and he wired to Lincoln saying, "We can take consolation in this. We've driven the enemy from our land." And Lincoln turns to his secretaries and says, "How do I convey it to these people? It's all our land." When your side begins to start absorbing the premises of the other side, you're in trouble. And my concern to you is, what are the premises that our friends put in place in order to bring about the overruling of Roe, a situation we desperately sought to gain? For the court in Dobbs did not pronounce on the wrongness of abortion. Indeed, my friends among the justices there sought carefully to avoid pronouncing such a judgment, as though it was solely a matter to be judged in the political arena, as though judges can take no official recognition of the condition and the human standing of the child in the womb. What we're seeing are the effects, the disabling effects, of a conservative jurisprudence shaped by some of our best conservative minds over the last 45 years. Justice Holmes famously said his hope was to drive every word of moral significance from the law altogether and give us a stripped-down, pure law detached from making moral judgments. And the curious situation is that it's fallen to conservatives in our time to preserve that curious legacy of Justice Holmes. And one curious result is that the American people seem to know no more about Roe today than they knew 49 years ago. Remember, Rich Derflinger of the Catholic Conference years ago found out that 60% of the public in surveys are opposed to 90% of the abortion performed under Roe, and most of them are opposed to overturning Roe. Well, how do you explain that? That most people don't know what's in it. 10 years ago, Marianne Glenda, my friend Marianne Glenda at Harvard, took the law school, took a survey among 25 of her colleagues. Only 5 of the colleagues at the law school could give an accurate rendering of what was in Roe. Our late beloved Gene Rostow, the sterling professor of law at Yale, one night almost gagged one night, not from the food, at our dinner table, when I explained to him that the right to abortion extends not only through the full length of the pregnancy, but even when the child comes out. Because we had one notable case in Tennessee in which a child survived an abortion for 21 days, undergone a surgery, and died. And the question was, we do have an obligation to protect that child? The answer tendered by Judge Hensworth was, no, that is not a child protected by law. That's a fetus marked for termination. The right to an abortion is a right to an effective abortion or a dead child. 49 years later, people still don't know that the overturning of Roe would not make abortion illegal about the country. The decision would simply return matters to the political arena in the states, so that abortion could still be performed in large numbers, as you know, in New York, California, other states. Now, how is it that 49 years later, our media, with their vast resources of research and their vast powers to broadcast, have not conveyed this point to the American people? And the reason now has become obvious, that the people who fill the media regard this kind of information as just too unsettling for the public to hear, and very likely to endanger that right to abortion they've come to regard as a deep anchor of their own personal freedom. And so some years ago, as Merlot suggests, some of us sought to engage this issue by offering a bill that would break out news that most of the American public would find jolting. We came forth with that bill called the Born Alive, awful language, Born Alive Infants Protection Act, to see if we could protect the child who survived the abortion. The pro-life organizations thought that this was just too modest to do any good. They had the bill on partial birth abortion with the grisly procedure of a child with the legs sticking out of the birth canal. The head of the child was crushed, the brain sucked out, and so the baby could be delivered whole, so to speak. But those were struck down. Judge Dick Posner in the Seventh Circuit would say, yes, I agree, these are grisly and bloody things, these partial, but many things are grisly and bloody, like nose jobs. But then he twitted us and said, but you never claimed the right to protect, the authority to protect the child. So why does the state have any compelling interest simply in shifting the killing of the child from the birth canal back to the uterus? And he had a point. So I said, look, let's go back. I'll take that line from Andrew Jackson's poetry, The Battle of New Orleans, where he supposedly said, boys, I want you to elevate them guns a little lower. Let's go back and fill in the premise that we can reach that child marked for an abortion. So with that, I was given the privilege of leading the testimony in the House back in July 2000. I had with me the brave nurse, Jill Stanek from Oak Lawn Hospital, Christ Hospital in Oak Lawn. And she blew the whistle on the live birth abortion, where the child is simply delivered whole and put in a refuse room to die. And this would be the safest of all abortions because no instruments were introduced into the body of the mother. Well, after we enacted the bill, Jill was on the air, and nurses were calling in from all over the country saying, my God, we've been doing that in our hospital for years. This was far more numerous and frequent than even we suspected. Our friends in the pro-life movement went reluctantly with this bill, and there was a strange mixture of disbelief and delight when the hearings opened on that bill, and the National Organization of Women, along with other pro-abortion organizations, came out in opposition to this bill, simply to protect the life of the child who survived. Our friends couldn't believe it. And this revealed a deep truth about our movement, that our adversaries understood the matter better than our own friends did, because they saw the principle that lay at the heart of the thing. And we never concealed it. We didn't come back to you and say, what was the difference in that same child 5 minutes earlier, 5 days earlier, 5 months earlier? And we said, well, we may not convince you, but perhaps from that vast volume of 1.3 million abortions, we could rescue a handful of lives. And from our point of view, there's nothing trifling or trivial about that. For the sake of averting, I call this kind of a looking, I wish it was called the title of this, not looking back and looking ahead. For the sake of averting a veto from President Clinton, the chairman of the committee, subcommittee of the House, Charles Kennedy, decided we'd drop all serious criminal and civil penalties from the bill, just make it into a teaching bill. And even so, it took strenuous work by Jerry Nadler in Congress to try to persuade the Democrat not to vote against. It's too modest, the bill. Don't give them the argument that just calls attention to the bill. And his advice worked. The public would not be jolted with the news as we thought, because the news would never be conveyed. The media blacked it out, as they black it out still today. Even Fox News blacks out our attempts now to go back to the original bill and restore those penalties stripped from the bill. Now, I'm calling this just to point out the dramatic change that has taken place within the Democratic Party over the last 20 years. It seems astonishing now that when that Born Alive bill was brought to the floor in 2002, the Democrats were in control of the Senate, and Harry Reid brought the bill to the floor. They still are embarrassed to vote against this. They wouldn't tell a roll call, they just have a voice vote, so nobody go on the record about this thing. Now, 20 years later, the Democratic Party has undergone a dramatic change. For we went back to the board now, we saw the killings going on in Philadelphia with that dirty clinic of Kermit Gosnell with babies surviving abortions, having their necks snipped. Something messy was going on there. It's called attention. So we went back to try to We brought the bill back. We've had 2 votes on it, September 15, 2015, January 2018. What the votes revealed, utterly cohesive parties. 241 Republicans, every Republican voted for the bill to protect the child. Every vote in opposition, 177 came from the Democrats. We've never seen this kind of cohesion before. This hardening and cohesion of the Democrats on this issue is now a brute fact in our political life. That for them, that right to abort, the right to get rid of that unwanted child does not stop even when the child is born. Now, I must confess that I really didn't start thinking seriously about this issue until the 60s. And one of the key essays that made an impression on me was the theologian Paul Ramsey's essay on reference points in deciding on abortion. And he'd take things back. Between the 18th and 20th weeks, the fetal heartbeat could be heard with a simple stethoscope. Now can be done at 6 weeks. After 12 weeks, the structure of the brain is complete. 9th to 10th weeks, there's squinting and swallowing. Fingers become discernible. But what's striking is that he traced it all the way back to the point of the zygote, no larger than the period at the end of the sentence, and say everything we have genetically, our allergies, our height and weight, perhaps our SAT scores, it was all there. And we realized that any of our mothers destroyed that zygote. We wouldn't have been the next pregnancy. That zygote alone was you or I. Now, I want you to see the surprise when, several years ago, a seminar of ours containing judges along with professors went back to the briefs written by those lawyers in Roe versus Wade, and we found they did an even more elegant job than Paul Ramsey did in marking off the chain, but drawing deeply on the findings, updated findings of embryology. It was a really impressive, elegant brief. And from that brief, they drew 3 key points they want to present to the court. That child, that offspring of the womb, has never been anything other than human from its very first moments. It receives its nourishment from its mother, but it has never been merely a part of the body of the mother. Okay? That brief, as I say, exquisite and compelling, and the enduring embarrassment down to our own day, was that neither the dissenters in Roe nor the 6 judges forming the majority now in Dobbs' case have drawn on this evidence and the reasoning and the conclusions it entailed. The brief in Texas in 1973, had virtually teed up things for the court. At that moment, the court could have made the kind of judgments that courts routinely make. Judges are called on every turn to say whether the state is justified in looking into the private driveway of a private home to search for a stolen vehicle, or whether the state is justified or unjustified in ordering the search of body cavities looking for illegal drugs. We do this all the time. The justices could have said, as they said in many other instances, we looked at the evidence and the reasoning, and we're compelled to conclude that the laws of Texas were amply justified. In this case, justified in casting their protections over those small human beings residing for a while in their mother's wombs. But instead of making that familiar move, the majority and the dissenters in Roe drew nothing from that rich body of material. The dissenters, down to our own day, retreated to a theory about the guidelines confining judges. Now, in our own work on natural law, we go back with Thomas Reed to those anchoring axioms of common sense that the ordinary person has to know before he starts trafficking in theories. Before the average man will start bantering with David Hume about the meaning of causation, he knows his own active powers to cause his own acts to happen, and he knows that he would not cast moral judgments of blame or praise on people for acts they were powerless to effect. Now, what I'm trying to suggest to you is that that same common man, unburdened with theories, would hear that Roe versus Wade was giving us a momentous case on abortion, in the most natural way, he'd want to know, well, just how did it come out? What did you have to say finally about the rightness or wrongness of abortion? But instead of explaining the ground of that common sense judgment, the dissenters, as I say then, and the majority now in Dobbs, simply invoked a theory about judges running beyond their proper lines of authority and flexing raw judicial power. It was a theory that the common man would not readily understand, and the truth has not been clearly explained even in our own day. What we'd hear day in and day out is that the right to abortion is nowhere mentioned in the Constitution, and therefore federal judges cannot proclaim any rights to abortion springing from that text. But as Jerry Bradley has pointed out, my friend, the Congress had ample reason in the past to make abortion the business of the national government, whether abortion is permitted in military hospitals, in diplomatic or military outposts abroad, in the territories, the District of Columbia, and the Congress had indeed barred abortion in those federal enclaves. There was nothing about marriage in the Constitution in 1967, when the court struck down those laws that barred marriage across racial lines. And you didn't find conservatives saying then, where's marriage in the Constitution? No conservatives challenged that case or sought a rehearing. But we heard again from Justice Kavanaugh in the Dobbs case that abortion was nowhere mentioned in the Constitution. In fact, the Constitution, he said, was neutral on abortion. Neutral. So the people in the separate states were free to vote it up or down. It apparently slipped a notice of Justice Kavanaugh, who said he was giving us a chilling replay of the Lincoln-Douglas debates, where Douglas was saying the way to rid ourselves of this divisive issue of slavery is that we leave it to the settlers in the separate states to vote abortion up or down, according to their own interests. Well, look, in Maine, they have laws on oysters. In Indiana, we have laws on cranberries. And some places use slave labor. For Lincoln, this was the degradation of the democratic dogma to say the regime was all process and no substance. You could achieve anything through this regime. You could vote for genocide. You can vote for slavery, as long as you do it with the trappings of legality, with a vote of majority. And we have to raise the question, is it really true that this Constitution, in its anchoring principles, is neutral on the matter of genocide? This Constitution, the regime begins with a recognition of the difference between innocence and guilt. That we don't visit punishment on people unless we have evidence proving that they're wrongdoing that deserves punishment. The right to life has never meant a right to life everlasting. You may not have your life put in harm's way in defense of the country. It meant the right of an innocent person not to suffer a lawless, unjustified assault on his life. And so we understand these deep principles. Could we really say that in these deep principles, could this regime possibly be neutral or indifferent on the question of whether the Constitution would license a regime of killing small, innocent human beings? Is that what these deep principles mean? Justice White, dissenting in Roe, deplored the possibility that the taking of small human lives could be ordered up for the sake of convenience. But then he quickly shifted the focus and transformed the question. The victim was no longer the unborn child who's being dismembered, but the people and the voters in the separate states were being deprived now of their freedom to deliberate on the question of abortion and just who is protected under their laws on homicide. And so the corrective trumpeted on the conservative side was to send the matter back into the political arena. The question put aside then, though, was just what was the nature of that living being who was at the center of the problem? Over the years, the courts had altered our understanding of who was that, quote, human person, as John Paul, that human person who was the subject of the laws and the bearer of rights. Lincoln approached the problem this way when he said, the question before us is whether that black man is not or is a man. If he's not a man, then he who is a man can do with him what he pleased. But if he is a man, he too has a right to govern himself. And Harry Jaffa would later say that question of whether the black man is a man cannot be a value judgment. Value judgment is a term that came into play with Nietzsche and Max Weber when people lost their confidence in speaking about moral truths. We would impute moral value to moral significance to anything as we value them. So would we estimate whether the black man was or was not a man, as people in the separate states thought they valued his life as a member of their own class or possible fellow citizen, right? Well, we skip ahead then to Planned Parenthood versus Casey, 1992, when one of my own dear friends on the court said, the question before us is whether that offspring of the womb is a human being, and he said there is no legal answer to that question. It must be a value judgment. Now I put it to you. If it made no sense to submit the human standing of the black man to value judgments in people in the separate states, it makes little sense for people to offer their value judgments when human life begins. Now, what could people say? When the child in the womb begins to squint at 9 weeks, when the fetal heartbeat can be picked up by Doppler instruments at 6 weeks. But none of these things, as you know, marks the beginning of a human life. They simply mark stages in the growth of the same being powering and integrating its own growth through different stages. The conservative majority in Dobbs would send the matter to the states, but on the premise that there is no truth to be known on this matter. But in the meantime, the blue states have been transformed. The court in Roe had not merely created a right to abortion, it changed the culture. It changed abortion from a thing abhorred, condemned, discouraged, forbidden, into a thing to be approved, celebrated, promoted. The culture of abortion will be flourishing now in the blue states to sweep away any lingering restrictions on abortion. The conservatives, schooled by Justice Holmes, thought they were doing the purely legal work of overturning Roe, but in the style of Holmes, they sought to mask to themselves and screen out all those words of moral significance about the nature of that offspring in the womb. And so 49 years later, in Dobbs, the conservatives would still not draw on that rich body of material about the state of the child in the womb, for it was ever clear now that the life of the child in the womb did not supply the ground of their constitutional argument or the object of their official concern. But the child would have supplied the ground of the judgment if the conservatives in Roe had taken the simple path of arguing that those laws in Texas were justified in casting those protections on small beings residing for a while in their mother's wombs. And those simple words, spoken now, would supply the predicate on which the Congress and the federal courts could enact under the 14th Amendment when the protections of the law are being withdrawn in the blue states from a whole class of human beings, just as the courts and Congress figured out in the 50s and 60s their authority to act when the protections of the law were being withdrawn from a whole class of black people in the South. The telling mark here is that of Justice Kavanaugh, writing that many pro-life advocates forcefully argue that a fetus is a human life. Argue, as though there's been no long-settled empirical truth on this matter found in all the textbooks on embryology. In other words, conservative jurisprudence, with this conservative jurisprudence, the judges must affect not to know the plainest objective truth that bears on a judgment here. That judgment is to be reserved to others, which is to say, conservative jurisprudence takes its beginning on this matter by its willingness to live affably with a radical falsehood. And that concurrence by Kavanaugh is the telling sign that even the opinion written by our beloved Sam Alito left the human standing of the child in the womb to the value judgments reached by people in the states, and so the child in the womb is still referred to as a potential human being, which makes no sense. If there's nothing living and growing there, abortion is no more indicated than a tonsillectomy. Okay. He may be a potential outfielder. He's never been a potential human being. We have again now the crisis of our house divided. And as with that earlier crisis, the balance is unsteady, and the dynamic will have to move to one side or the other. And I'm afraid that the things have been tilted against my side now. For the culture of abortion is flourishing in the blue states, and there are new forces arrayed against us that are considerable. We might find, though, that it's never out of season to bring forth that Born Alive Infants Act, Born Alive Infants Protection Act, even in the blue states, to see if we can create a fissure in that wall of opposition to pro-life legislation, to see if even people in the blue states are willing to turn away from protecting the child who survives the abortion. The court refused to say anything about the rights and wrongs of abortion, and so did nothing to foreclose the Democrats, fueled by a new anger from losing all those levers of federal power, to sweep away all those lingering barriers to the promotion of abortion as a positive good. Friends recall the Hyde Amendment in place since 1976, supported by Democrats, when they're still pro-life Democrats. But now this new bill, the so-called Women's Health Protection Act, by the Democrats have offered, would sweep away all of those restrictions and even more, sweep away even protections of conscience for doctors and nurses who do not want to be implicated in this. A dear friend of mine in the neurosciences once told me that a light held to the retina reveals a vast amount of information about the state of the organism. I think that Dobbs is the light held to the retina. And what it reveals are some divisions running quite deep among the conservatives themselves. The point's been made for years that the conservatives, with their insistence on positivism as a source of all rights, their willingness to see abortions voted up or down, have given us a replay of Stephen Douglas in a debate with Lincoln. What Lincoln said of Douglas could now be said of conservative jurisprudence, that it offers us a false statesmanship, a jurisprudence that actually prides itself on having nothing of moral substance to teach. The one moral claim it does make is that it's vindicating the right of our people, not our judges, to govern ourselves. But that right depends, of course, on that proposition in the Declaration of Independence. All men are created equal. No man has by nature the rule of other men. The only right just government over human beings depend on the conservative government. But conservative jurists such as Justice Scalia tell us that's not part of the Constitution. It has never been enacted in the positive law. And what they're missing was John Locke's old point. This is one of the things that must be antecedent to the positive law before you know who has the authority to make that positive law in the first place. Okay. Stripped of that principle, if we ask, what's the ground then on which the majority rules the minority? The answer given by Justice Holmes and Justice Scalia is, it depends on the brute fact that the majority can overbear the minority, which is to say, as Rousseau had it, might makes right. That premise really means the denial of any moral ground for our law. I have in the court three men I regard as friends, and I think they found themselves compelled to move in the grooves marked by conservative jurisprudence over the last 40 years. And those lines have led us now to a terminal positivism that can't give a coherent account of itself. And so herein lies conservative jurisprudence and its debris. The judges held back from dealing with the moral substance of the case. They handed the task on to a conservative political class, too defensive now and too cowed to argue that something positively good and rightful can be done in protecting babies from being poisoned or dismembered, or to express surprise and sadness that some women in the suburbs would feel diminished as women if they had to forego the freedom to kill the babies they were carrying. The conservative leaders tell us, don't worry, people care more about inflation. Not a battle cry. With the judges holding back from teaching, with the political class distracted and bewildered, there falls to the rest of us now a heavier burden of argument, and a call to steady work. We curiously find ourselves in a situation eerily like the one we encountered in the spring of 1989, when the court dealt with the Webster case from Missouri and took what we thought were the first steps in returning the issue of abortion to the political arena in the state. And I raise the matter now because we seem to be confronting precisely the same thing. When the court made that move to return the abortion issue to the states, it produced a certain crisis and panic among Republican politicians like Jim Carter in New Jersey, who suddenly faced with, he could be pro-life while he was safely removed from any authority to act on those convictions. Now he's faced with women in New Jersey professing anger at being dispossessed of a right they've come to consider essential to their freedom. So we found Republican politics in the aftermath of the panic take 180 degrees turns, becoming fervent pro-choicers. What we obviously needed was someone in authority just to frame the problem and stop the panic. Anticipating that point, I was invited to do a draft for President Bush that moved along these lines. I've had President Bush say, look, we've been governed by the courts for so long that we need a conversation before we begin legislating again. The other side tells us abortion is not infanticide, which means they're willing to protect the child at some point. Why don't we invite them to tell us when they'd like to begin, and we'll meet there. If nothing else is forthcoming, why don't we start with protecting the child who survives the abortion, born alive? My point is, you frame the issue. Come forth with something moderate, that nobody here is going to disagree that the woman has a right to an abortion when her life is in danger. That we're going to get scare attacks over that now. We assure people, come forth with something moderate, the Jim Carters of the world can get through the day and nobody panics. I wrote some of the best things that Ronald Reagan never said, and I had one thing that George Bush never said. But we have that same situation where we have the need of someone, a political figure, to come forth and frame the issue. And at this moment of high tension, I sense again the absence of that figure. And I did a memoir of my experience with the Born Alive Act in the book called Natural Rights and the Right to Choose. And if you'll forgive me, I would end here with what I had to say then, with the same burning sense now. I said that a political class that has lost the sense that arguments and reason matter is a political class that may serve in positions as officers of state, and yet its members who have lost their vocation. Because at times the need to clarify the principles entails the need to stage a confrontation or the debate, and there may involve at times the need to pick a fight. A political class that's persistently reluctant to show that spirited nature will produce not merely a politics that is banal, but that is denatured. For in removing the conflict or removing the argument, we might gently remove as well the moral substance. Now, Aristotle remarked in one of those memorable passages, if the art were in the material, we would see ships growing out of trees. But ships were not produced by the laws of nature. Ships were part of a world formed by design, by the awareness of ends, and the shaping of reasons. So we may be bringing forth a political class now, my worry, more and more detached from the sense that there's any particular importance in compelling the other side to come out with their reasons and claim them as their own, and to a political class molding itself in that way. We may not only ask, well, where is the reason that gives meaning to political life? But where in all that is the art? Where do you find the distinctive hand that marks your work? Where do we find the design that marked your understanding? The touch that reflected the experience that you had cultivated? And where, finally, do we find the impression, lingering through time, that you were here? That's it. Thank you. Okay. Okay.